Be ready. Start. When the above miscellaneous first appeal came up for hearing, a division bench consisting of the Honorable Mr. Justice K.A. Abdul Ghafoor and the Honorable Mr. Justice K.M. Joseph noticed that there is apparently conflicting views expressed by two division benches on the question canvassed by the appellant, the Oriental Insurance Company Limited, namely whether compensation could be awarded separately on account of permanent disability and also an account of loss of earning capacity. The learned judges were of the view that since the question is raised most often, an authoritative pronouncement on the issue is required to be made. The question has referred for consideration of a full bench in the above contest. Para. Sri V. Hariprasad, first respondent herein, aged about 18 years, sustained an amputation injury in an motor accident which had occurred on 13/11/1993, whereby his right hand had been chopped off from the shoulder. Evidently, the trauma and loss suffered was substantial. A claim under Section 140 and 166 of the Motor Vehicles Act read with Rule 371 of the Kerala Motor Vehicles Rule 1989 was God preferred. He had claimed a total compensation of rupees 5,32,284 for the injuries that he had sustained. During the period concerned, he was a student and was not earning member, and he had not claimed any amount for loss of earning. The Motor Accident Claims Tribunal had granted rupees 1500 for transportation expenditure, rupees 7500 towards extra nourishment, rupees 500 as compensation for damage to clothing, and he had been directed to be paid 62,000 towards medical experience incurred. Rupees 50,000 had been awarded as compensation for pain and suffering. In respect of the claim for compensation for continuing permanent disability and for loss of earning power, respectively, rupees 1,92,000 and 1,28,000 had been awarded. A sum of rupees 25,000 has been awarded for loss of marriage prospects. On the heads of the disfigurement and the loss of amenities in life, a sum of rupees 25,000 had been awarded. The above award of the tribunal had been subjected to challenge by the insurance company. The contention of the appellant was that when permanent disablement is adequately compensated, there arises no question of granting a further compensation on loss of earning capacity. The first respondent, on the other hand, justified the grant as above made by the tribunal, as according to the counsel, the compensation on account of permanent disability and compensation arising out of loss of earning capacity come under two distinct and different heads, and these always were, of course, subject to the discretion of the tribunal. It was submitted that, taking notice of the peculiar facts that the first respondent was a student who was yet to enter the employment market, above yardstick alone would have rendered justice. Reliance had been placed on a bench decision of this court in KSRTC versus Pidambaram 1994 in bracket 2 KLT 717. The Madras High Court in Tiruvallar Transport Corporation versus Thangavelu 1996 1 KLT SC 6 case number 9, according to the counsel, had examined the issue and had held that necessarily the tribunal was obliged to come to the conclusion that these two heads are different and distinct for awarding compensation. In addition to the decisions referred to the above, the Council had adverted to some other judgments as well. General principles too had been cited. The cleavage in view is apparent and had been noticed by the division bench as could be seen from the reference order. We will examine the question in the above said background. Chapter 10, 11, and 12 of the Motor Vehicles Act deal with the issue of compensation, insurance, and adjudication of claims in respect of accidents arising out of the use of motor vehicles. On receipt of an application, the claims tribunal constituted under the Act is to make an award determining the amount of compensation which appears to it to be just. What is the just compensation has not been specified by the Act and it may vary from claimant to claimant and depends upon a variety of circumstances. That a sufficiently large amount of discretion has been granted to the tribunal is evident from section 169 of the Act. Subject to rules that may be made on this behalf, it is authorized to follow such summary procedure as it thinks fit. Rule 371 of the Kerala Motor Vehicles Rule provides that the application for compensation is to be made in the form of prescribed. It can be safely be assumed that in a claim for compensation for personal injury, the attempt of the tribunal is to compensate the victim. No other method has so far been possible to be employed than to compensate him with money. It is also universally accepted that an injured is entitled to recover compensation for having suffered pecuniary loss as also for non pecuniary loss, but in the latter instance, compensation in terms of money is the only possible course. Stop.